Our next witness today was introduced, the Honorable Heather Carruthers, the County Commissioner from Monroe County, Florida, and she's testifying on behalf of the National Association of Counties. Again, thank you for being here, and please proceed with your statement.
Thank you, Chairman Schuster, Ranking Member DeFazio, and distinguished members of the committee for this opportunity to testify on FEMA's role in local land use decisions. My name is Heather Carruthers, and I'm an elected county commissioner from Monroe County, Florida, home of the Florida Keys, and today I'm representing the National Association of Counties. The topic of this hearing is of great importance to my county and to many other counties across the United States. In fact, in Monroe County, we've been dealing with this issue for more than 3 decades, initially through locally originated efforts and eventually through the courts. The National Flood Insurance Program is vital to us, and any changes to the program and its requirements directly affect our residents, businesses, and local economy. Although counties are highly diverse across the country, we share many of the same goals and responsibilities. We establish local land use policies that protect our natural resources and environment, but also provide the tools and foundation needed for development that helps our communities. In Monroe County, we have worked diligently to identify solutions that help us balance both of these goals. Today, my remarks will focus on 3 points. First, local governments work daily to craft land use policies that protect endangered species, mitigate disasters, and facilitate economic development in compliance with existing state and federal species protection regulations. In most states, land use planning and regulation is carried out primarily at the local level. Through this land use authority, we help to shape the local communities within our jurisdictions. In my county, we have approximately 30 endangered and threatened species. We work to protect these species and their habitats in many ways, including establishing ordinances that limit construction and development in specific areas of the county. Our local regulations cap building permits for many reasons, the most important of which is to protect environmentally sensitive land. These local land use policies are developed through extensive coordination with our communities as well as our state and federal partners. We have long required coordination with the Fish and Wildlife Service before issuing any building permits. Second, because NFIP is so important to our flood-prone communities, local governments have little choice but to comply with its participation requirements. In 2012, the Government Accountability Office estimated that about 95% of the nation's counties had NFIP policies in their jurisdictions. In Monroe County, we have over 27,000 NFIP policies, and Florida as a whole has over 1.8 million. The importance of the NFIP to our county was highlighted when in 2005, a federal court halted issuance of new NFIP policies for nearly 50,000 parcels in Monroe County, following a lawsuit filed by conservation groups, even though we had already carefully developed comprehensive land use policies to protect our environment and native species. For 7 years, this FEMA injunction remained in place, and owners of the parcels were unable to build. Construction costs skyrocketed, and the permitting process dragged. We documented instances of homeowners paying over $1,000 more in permit fees and waiting almost a year for Fish and Wildlife Service approval before they could proceed. The only homeowners and businesses that were able to move forward were those with deep pockets who could do without flood insurance. And as you can imagine, this really hurt our working families and small businesses. It further slowed economic growth and drove up business and housing costs. Finally, species protection regulations carried out through NFIP have typically been one-size-fits-all solutions that consider neither the variance in local communities nor our existing species protection efforts. As a result of the previously mentioned lawsuit, reasonable and prudent alternatives, RPAs, required our county to revise our flood damage prevention ordinances. We were required to implement a new permit process that was essentially a repackaging of existing county regulations with multiple layers of added bureaucracy. Owners of properties within endangered species habitat areas were already required to seek Fish and Wildlife Service approval before getting county permits for development. FEMA's review did not take into consideration the unique circumstances of our county ordinances and procedures. Ultimately, no additional habitat acreage was protected. In short, the entire process added no real value to the species protective measures we had already developed and enforced. It simply added more red tape and cost. As you can see from this permit review process flowchart, this is what is required of a homeowner, a property owner, before they can get a building permit. And it does not even include what happens at Fish and Wildlife or FEMA. So thank you again, Chairman Schuster, Ranking Member DeFazio, and members of the committee for this opportunity to provide the local perspective on how advancing species protection efforts through NFIP is problematic and ultimately counterproductive at the local level. And I'm happy to answer any questions that you may have.
Thank you, Commissioner Carruthers.